You open the mail, or maybe you get a phone call, and the reality hits you. Your spouse has moved out of state. Perhaps they took a new job overseas, or they've just been stationed abroad with the military. And you're left sitting right here in Washington, D.C., wondering if a D.C. divorce is even still a possibility. Well, it absolutely is. As a D.C. family law attorney who's personally guided residents through long-distance divorces involving spouses in more than a dozen states and several different countries, I can assure you there is a clear path forward here. This explainer covers exactly how DC's residency rule and the 2026 virtual court procedures allow a DC resident to get divorced without their spouse ever setting foot in the district.
So the really crucial point to grasp right off the bat is that physical distance doesn't stand in the way of a legal resolution. Under DC law, living apart from your spouse doesn't block you from filing a complaint. Thanks to the court system's modernization, an uncontested divorce can now be completed with a literally 0 hours spent inside a physical courthouse. Which naturally leads us to question 1. Can you still file for divorce in DC if your spouse lives in another state or country? All right, let's dive into the 6-month bona fide residency rule, because it's essentially the foundation of your case. Under DC law, only one spouse actually needs to meet this requirement. You simply must be a continuous DC resident for 6 consecutive months right before filing your complaint. The other spouse? They can live anywhere else in the United States, or frankly, anywhere internationally. Their location is entirely irrelevant to whether the D.C. Superior Court has jurisdiction over your divorce. And just a quick note, temporary absences, for work travel or military deployments, those do not break your continuous residency status. The court just requires concrete proof that you live here, which means you'll need to provide documents like a D.C. identification card issued 6 months prior, consecutive utility bills, or a long-term lease agreement. Okay, so once we establish that the court actually has jurisdiction, the very next logistical hurdle people worry about is travel. Will you or your out-of-state spouse have to go to court in person, or can the entire case just happen remotely? For the year 2026, the D.C. Superior Court formats are pretty clearly defined. For uncontested divorces, meaning you and your spouse agree on all the terms, the process is fully virtual by default. These hearings are conducted securely via WebEx, meaning absolutely 0 courthouse hours are required for either of you. Now, on the flip side, for contested trials where parties are actively disputing assets, custody, or support and require actual witness testimony, the default is presumptively in person. However, hardship requests for remote participation are very frequently granted by judges when an out-of-state spouse is involved, so virtual participation remains highly accessible. That brings us to question 3, a highly specific procedural step. How do you legally notify your spouse of the divorce if they're far away, or, as happens sometimes, their exact location is currently unclear? DC law strictly dictates how this notification, which is known as service of process, must be handled. There's a specific hierarchy of methods here for serving an out-of-state spouse. Step 1 is utilizing certified mail with a return receipt. It's inexpensive, but it only really works if your spouse is cooperative and will actually sign for the delivery when the postal worker shows up. If that doesn't work, step 2 is hiring a professional process server for domestic or international delivery. A licensed server will physically track down your spouse, hand them the documents, and then file an official affidavit of service with the court. And then step 3 is service by publication in a DC newspaper. But keep in mind, this is strictly a last resort. It's utilized only when your spouse's location is completely unknown and you've demonstrated to the court that you've made diligent, exhaustive efforts to find them. The article breaks down exactly how much each method of serving an out-of-state or international spouse costs, and that full comparison is linked in the first comment below. Moving right along to question 4, because with service complete, we have to set some realistic expectations regarding time. How much longer will this entire process take if your spouse decides to contest the divorce? Or maybe they simply don't respond to the filings at all. Let's look closely at these long-distance divorce timelines. An uncontested virtual divorce with a highly cooperative spouse is pretty fast. It'll typically take 30 to 90 days from filing to the final decree. Now, an uncontested divorce involving a spouse who delays their response, that will take approximately 120 days. A contested divorce that involves some back-and-forth negotiations but eventually settles before trial will take around 6 months. And finally, a fully contested divorce that proceeds all the way to an in-person trial will take anywhere from 15 to 18 months. Because while virtual proceedings have definitely eliminated those old delays caused by coordinating travel schedules, complex litigation still requires extensive time for discovery and trial preparation. Let's pivot to some specific edge cases that are particularly common in our region with question 5. My spouse is active duty military. Does that delay or complicate things? The key number for military families to remember here is 90. Under the Service Members Civil Relief Act, often called the SCRA, Active duty military spouses are entitled to request a 90-day stay of proceedings. If their military duties, like a deployment or specialized training, prevent their participation in these virtual hearings we talked about, the court must grant this 90-day postponement. In fact, the court is legally prohibited from entering a default judgment against them without first verifying their military status and appointing representation. It's a system designed to ensure deployed personnel are fully protected while they're serving.
That brings us to another extremely common scenario in the district involving federal government benefits. Question 6. Where federal employees, how does our thrift savings plan or FERS retirement get divided if we're not actually divorcing in the same state? So there's a strict legal distinction here, and it applies regardless of where either spouse resides. If you're dividing a private sector 401k, the court uses a standard qualified domestic relations order, commonly known as a QDRO. However, if you are dividing a thrift savings plan or a FERS pension, a standard QDRO just won't work. You absolutely must use a specialized retirement benefits court order. This specific order is required to meet the strict guidelines of the Federal Office of Personnel Management. If your order doesn't conform precisely to OPM standards, your retirement distribution will be rejected outright and delayed for months. Before we wrap up the core legal facts, I need to issue a brief but really critical warning regarding child custody jurisdiction. It is entirely possible for the D.C. court to have jurisdiction to handle your divorce and your property division while completely lacking the authority to make custody decisions. Custody is determined by the child's home state under federal law, and the home state is strictly defined as where the child lived for the 6 consecutive months immediately prior to filing. So if your children have been living in another state with your spouse, this can create a situation of split jurisdiction across 2 entirely different state courts. That's a scenario that requires very careful legal strategy to avoid fighting complex, simultaneous battles in competing jurisdictions. The fundamental takeaway to remember from this explainer is that living apart from your spouse, even if they're in another country entirely, does not stop a D.C. resident from filing and finalizing a divorce completely through virtual proceedings. The full article walks through the exact filing steps, the service of process costs, and how federal retirement benefits get properly divided, and it's linked in the first comment below. Please subscribe if you want to ensure you have clear D.C. family law guidance like this without having to search for it every single time. With virtual courts effectively erasing state lines for divorce, it really begs the question, will the future of family law eventually eliminate the concept of physical jurisdiction altogether?